and kia ora everyone. Thank you very much for taking the time today to attend this session, a Privacy 101 for DHB staff. I'm not sure whether all of you guys are from the DHBs or not, but hopefully it will be of value for you if you are working in the health sector. The theme of this Privacy Week in 2020 is privacy and the foundation of trust. That's not a new concept or understanding, and it's particularly not so in the health sector. As health providers, trust is critical to the work that you do, and you will collect and be entrusted with huge amounts of personal health information. You'll get that from individuals so that you can provide them with services and do your job effectively and safely. You'll also be aware that creating and maintaining trust of consumers is critical to ensuring that you can do your work well, and that includes protecting their information, respecting their information, and ensuring that those that use it are only those that need to and that they use it appropriately. I think also working in the health sector, you'll be really familiar with the impact that privacy breaches can have on people and on their trust, or where information is used in ways that they don't expect. Sorry, I'm a little bit unfamiliar with the setup with Zoom, but that's all right. I've included a few recent media clippings of some privacy breaches within the health sector, just really to demonstrate that point. And of course, with the coverage that came last year around the access by ACC staff into sensitive files, I'm not there to say whether the access was appropriate or not. ACC, at least at this stage, with the articles that were saying that the 350 times that a claimant's sensitive file was accessed were all justified access. But what this media clipping and story really demonstrates to me is that where there's a mismatch between an individual's expectation around how an understanding about when their information is going to be used, by whom, for what, and the way in which an agency needs to access and use information in order to do its job, there will be a breakdown in trust. And you'll see that second article there, that the trust is not just with the individual who raised concerns around the access into their files, but filtered more broadly in terms of other claimants being urged to check what access had occurred in their own files by ACC staff. Of course, that's the importance of ensuring that consumers understand how their information is going to be used is a key focus of Rule 3, and we'll look at the information privacy principles and the health information privacy rules in a moment. As Jess explained, I will first just give a little bit of an overview of the Act and the rules and how they work in the health sector. We've then had a few questions pre-submitted relating to filming in DHBs, remote consultations, and then around breaches. But if you do have any questions that you'd like addressed, please do use the chat function, which I will try and keep an eye on as we're going through. And if there's additional questions that we don't have the opportunity to answer in the hour that we've got today, it may be that we can follow up with some written information subsequently. I also just mentioned that we're really interested in hearing from you about the resources that we have, and in particular the training modules that we run online, the e-learning resources. And we will be sending out a survey just asking for you to share your views about what works and what you're looking for in that. And indeed encourage, if it's possible, to share that survey more widely within your organisations as well. So the Privacy Act 2020, we got a new act, a refresh of the old legislation came into effect in December 2020. Unlike the previous Act, it had a specific purpose section, although the purposes are very much an integration of the Act with a few tweaks. So the purpose of the Privacy Act is to promote and protect individual privacy, and it does that by providing a framework for protecting an individual's right to privacy, including their right to access their personal information, but at the same time recognising that other rights and interests may need to be taken into account. And it's that balancing between an individual's right to privacy and other interests that you'll see through the restrictions that apply when an individual requests access to their own information, those limited circumstances in which you can withhold information from them. And also when you look at the core of the Act being about information being collected and used for a particular purpose, but the extensions of that use and disclosure to recognise that in certain circumstances, other interests might be engaged and may take precedence over an individual's right to privacy. So the Privacy Act applies to actions taken in respect of personal information collected or held by agencies. Personal information is extremely broadly defined. It's information about an identifiable individual. So it doesn't need to be particularly sensitive information, although of course in the health setting, you will be entrusted with very sensitive information collected from individuals in extremely vulnerable circumstances. It applies to all agencies, so right across the economy, whether that's your supermarket, where you take your car in to be fixed, the cleaners that you contract with, your health practitioners and agencies. One of the key parts of the Act is the Information Privacy Principles, which governs the way in which information can be collected, held, used and disclosed, and when it must be disposed, as I said, to all agencies across the economy. There's other requirements set out in the Privacy Act. They include this new requirement brought in by the 2020 Act for mandatory breach notifications, and we'll touch upon that part of the Act in some detail in a bit. There's also a requirement for all agencies to have a privacy officer. This is quite a core requirement and something which, when things go wrong and you either are dealing with a complaint or a privacy breach, and we ask to talk to the privacy officer who's got that role in terms of being a point of contact for our office as well, it's never a particularly good look if the agency has to turn around and say, well, what's that? Or we don't have one. It's a basic requirement that all agencies have to have a privacy officer, and they are tasked with ensuring that the agency thinks about and considers and complies with the privacy obligations imposed on them, but also, as I said, that point of contact between the agency and our office. There are some limited exceptions to the Act's application. It doesn't apply to the news media in relation to their news gathering activities, and that's something which is not necessarily well understood. The news media is governed through their relationship with the Broadcasting Standards Authority or the Media Council, so there is a separate regulatory framework that applies to news media and the news gathering activities. The Act also doesn't apply to the judicial functions of a court or tribunal, and other exceptions include the Sovereign, the Governor-General, members of the House of Representatives, Parliamentary Services Commission, for instance, the Ombudsman, or any inquiry that's set up through legislation or through the powers of inquiry. It also doesn't apply in most circumstances to individuals. Individuals will not be subject to almost all of the IPPs where they're collecting or holding personal information solely for their domestic or personal affairs. There are a couple of important exceptions to that. Firstly, it doesn't preclude the requirement for individuals to collect information lawfully, so IPP4A still applies. And also there is a threshold that it doesn't, where it reaches the threshold of being highly offensive to an ordinary reasonable person. I also mentioned that the Privacy Act has slightly limited the scope of the domestic and personal affairs exception, and that the information has to be collected or held by the individual solely for that purpose. The 93 Act didn't have that limitation of the solely requirement. And I think that particularly is that divide between our personal affairs and our work affairs as people are finding opportunities to monetize or have side hustles and the like, that divide between what is our domestic and personal affairs and what is solely created or held for that, collected or held for that, will become, increasingly grey. Well, the Privacy Act applies across the economy. The Commissioner can issue codes of practice, and those codes of practice can either attach to specific types of information, to specific agencies or classes of agencies, in particular industries or professions. And the Health Information Privacy Code is one of those codes of practice issued under the Privacy Act. It modifies the information privacy principles and it sets specific rules for agencies in the health sector. So health information is defined very broadly. It includes information about the person's medical or treatment history, information about any disabilities or treatment that they have or treatment that's been provided, and any information that's collected in the course of or incidental to the provision of health or disability services. If you take the DHB as an example, the DHB will hold a whole heap of personal information in different classes and types. Patient information will be one of those, and that will be subject to the Health Information Privacy Code. Of course, DHBs will also hold personal information in the form of their employment or HR records. Those are not health information, and they will be governed by the information privacy principles in the Privacy Act. The rules in the Health Information Privacy Code are more restrictive than the Privacy Act, and that recognises that the information is particularly sensitive, that it's collected in a situation of trust and confidence, and also that within the health space, the importance of patient autonomy and consent is heightened. And so a lot of the differences between the Health Information Privacy Code and the Privacy Act are around the importance of patient authorization. There's also specific scenarios where the Health Information Privacy Code allows information to be used or shared that are health specific. The Health Information Privacy Code also requires health agencies to designate a person within the organisation to deal with complaints and to have a complaints procedure. That complaints procedure provides for the acknowledgement and management of complaints alleging a breach of the Health Information Privacy Code, and it mirrors the complaints requirements for in the Health and Disability Code for that applies for the provision of services under the HDC Act. That is something which is imposed by the Code of Practice, the Health Information Privacy Code, rather than being a general requirement in the Privacy Act, although the expectations on agencies to acknowledge and to deal with, investigate and respond to complaints really does apply across the economy as well. So just quickly turning to the privacy principles in the Act and the rules in the Health Information Privacy Code. As I said, they cover the life cycle of information. So from the collection of information to the holding, use and disclosure of it, and to the safe disposal of it once you no longer need it. So in terms of collecting information, you should only be collecting information that you need. There's a Rule 1 has within it a data minimization approach. You should be collecting it from the person concerned. Of course, there are some exceptions to this, and you will all be familiar with how those exceptions might apply in practice. For example, if you have a patient who's unconscious arrive in ED, it will not be practical to collect information that you need from them, and you'll be looking to other people or other sources. When you're collecting information from the individual, you need to tell them what you're doing with it. You need to tell them why you're collecting it, how you're going to use it, for what purpose, who the intended recipients are. And as I mentioned at the start, this transparency requirement of making sure that individuals understand what information is being collected and why and how it's going to be used is central to creating and maintaining, promoting trust and confidence. When you're collecting information, you need to be considerate. You need to collect it by fair means, and you need to be particularly careful about how you collect information from children and young people. When you've got information, Rule 5, you must keep it secure. You must have reasonable security safeguards to ensure that it's protected against misuse or disclosure, inappropriate disclosures. So that will be thinking about your security on your IT systems, but it'll also be thinking about where else in your organisation health information is recorded. For example, can patients see the whiteboard in the nurses' station, which sets out information around who's in, what their requirements are? I have visited a lot of DHBs when providing legal services to them, and it wasn't unusual for me to come across a run sheet that a busy doctor or nurse had dropped in the bathroom. So thinking about all of those repositories of information and what security steps you take to ensure that that information is secure. Do you collect the run sheets up at the end and safely destroy them? Rule 6, the right to access information, personal information that's held by an agency. So to get confirmation as to whether or not personal information is held and have a right to access it when they do. That right to access is, of course, has limited exceptions in the Act, and they are set out in the Act rather than the Health Information Privacy Code. The right for individuals to seek correction of the information when it's wrong, or to have a statement of correction added. When you hold information, you've got an obligation under Rule A to make sure it's accurate before you use it. Rule 9, to dispose of it when you no longer need it. And of course, in the health setting, there will be requirements around the retention of health records, for example, under the regulations that apply, but also the DHB will be subject to the Public Records Act, so the General Disposal Authority that sets out minimum retention periods for certain classes of health information. When you've got information, Rule 10 says that you should be only using it for the purpose for which you collected it. There are, of course, some exceptions to that. So where there's a directly related purpose, for instance. Rule 11, if you're looking at sharing it outside of the agency, it should be one of the purposes, so something that the individual will be aware of. You can do so with their express authorization. And again, there is some movement or some wriggle room within Rule 11 as well, with recognised exceptions where that individual's right to privacy may need to yield to other interests. For example, where it's necessary to prevent or lessen a serious threat to the health or life of an individual or to public safety. Rule 12 is a new principle that was brought in with the 2020 Act and relates to sharing information overseas. So if you're sending information overseas, it must be adequately protected. And then Rule 13, only using unique identifiers when it's clearly allowed. The National Health Index number is an example of a unique identifier that's used within the health sector, and there are specific rules in the Health Information Privacy Code, which enables the same number, the NHI, to be used by multiple health agencies, and that's a change from the general restriction on unique identifiers only being able to be used by the agency that assigns it. The health context also raises a lot of other legal and ethical obligations. So the Health Information Privacy Code is part of a rich fabric of obligations that sit on you as health providers. So as a health provider, you must also comply with the HDC Code of Rights. And one of the rights in that, for example, is the obligation to ensure appropriate cooperation and coordination of services between providers. So that acknowledges that information will need to be shared, for example, between practitioners providing care. There's also professional and ethical obligations that will attach to you as health practitioners, which you need to be mindful of. They may impose more stringent obligations on you than the Health Information Privacy Code. For example, the duties of confidentiality that you are obliged to comply with in terms of your relationship with your patient may have greater importance under those codes than under the Health Information Privacy Code. It's also important to be aware of what your employer's expectations are, because of course, as an employee, you are expected to comply with your employment policies and procedures. That will also be relevant when there's a complaint about the use or provision of information, to see what you've told, what the expectations are internally. They might, for example, set out a procedure that needs to be followed, or people that you need to talk to, or who has the delegation to make a decision around the sharing of information, particularly when it's outside of your agency. There is also a huge number of other statutes that will be relevant to sharing information within the health sector. Other legislation might require or authorise the provision of personal information, or it might restrict or prohibit the collection, use or disclosure of it. And you need to be aware and mindful of those. By way of an example, in the child protection and family violence space, the frameworks for information sharing set out in the Oranga Tamariki Act or the Family Violence Act will be relevant. In the COVID context, for example, the laboratories are required to report a COVID positive status through under the Health Act, and the contract tracing that we've seen so much of, particularly in the earlier stages of our COVID response, was managed under the provisions of the Health Act. There's numerous examples reporting of deaths to the coroner, providing reports as part of that process or as part of an investigation or inquiry by the HDC, by our office, by a royal commission such as the Commission of the Inquiry into Abuse in Care. In the employment space, there's legislation that deals with, for example, the safety checking of workers under the Children's Act that requires the collection of and provision of particular types of information. There's also provisions that enable employers or require employers to report matters to the regulatory authorities under the Health Practitioners Competence Assurance Act. So if you are resign or dismissed for reasons relating to competence, there's a reporting mechanism there to the responsible authority. I just also want to mention that interactions within the health sector you will be collecting a huge amount of personal information, and of course that is absolutely central to the work that you do, and compliance with your privacy obligations will be an integral part of good information handling procedures, but also that's closely linked to good clinical practice. Now, I will just quickly look at the questions to see if there's something that has come up. So before I launch into the discussion on filming, I'll just pick up here. So a question around privacy officers. With all agencies requiring a privacy officer, what does this mean with the move to Health NZ? Will this sit with Health NZ, or would each locality and hospital require a privacy officer? Well, the requirement in the Privacy Act is for the agency to have a privacy officer. So the legal requirement will be for Health NZ to have one. I'm not totally over the provisions that relate to the localities in the Paiora legislation, but I think in practice, there will be responsibilities that will be delegated out into the various regions. So I expect that within each hospital or region or something, there'll be a structure of who's got responsibilities for assisting with the practical compliance with the privacy obligations. Just in terms, we've got another question here around working for a tertiary institution which has got a health centre and a school that trains health workers across a number of fields. Yes, you're quite correct. The Health Information Privacy Code will apply to those parts of the agency that are a health agency. So it won't be the entire school. It will be the health centre will be, and the part of your institution that's training the health practitioners will be as well. As I said, often those interactions are not as, we often think of the Health Information Privacy Code and the Privacy Act as being quite separate. The differences between them are often more moot. As I said, it does they are more restrictive in some circumstances, and they certainly elevate the requirement of authorisation. But by and large, the duties that will attach if you're a health agency are also those which will attach if you're just subject to the Privacy Act. I will just move on because I'm conscious of timing to filming. So this was a question that was raised in advance, and I think it demonstrates some of the factors and the difference between the Privacy Act and the Health Information Privacy Code as well. So there's sort of three situations where filming might arise. Filming by patients, filming by clinicians of their clinical consult, and then the sort of more general filming for, sort of CCTV purposes, where you're using it for security purposes. Filming by patients is something that comes up a bit. And I think it's important to first think about why patients may wish to film a particular interaction. It might be because they don't want to forget the discharge information or the information that they've been told as part of the consult. It might be because then they're not trusting the practitioner or the organisation, and they're wanting a record of what was said, or because they're wanting to be able to access a second opinion later. Generally, an individual filming their own consults isn't going to engage the information privacy principles in the Privacy Act. And that's because it will likely be solely for the purpose of their domestic or personal affairs, and we're not going to be at that threshold where it's highly offensive. I do know from experience that employees can be very concerned about filming. It doesn't necessarily promote a trusting relationship between the patient and the clinician. Practitioners may feel less able to speak frankly, or they might be concerned that the information might be shared, for example, on social media, and that they will be subject to ridicule or public exposure that they don't believe is appropriate. It is, of course, open to organisations to set a policy around filming on their premises, and I know that some DHBs do that and have posters up, for example, saying that you're not permitted to record. The issue of enforcement can, of course, become a little bit fraught, though. Can you really refuse to provide care if the patient or the whānaus insist on recording the consultation? It's probably not so much of a privacy question. If the patient was filming other patients, though, particularly when they're in vulnerable circumstances, that might give rise to that highly offensive sort of threshold and we'd need to consider a complaint if we received something along those lines. But I really think, as with most things, the best approach is probably to try and work with the patient to really understand and address the reasons that they're wanting to record the consultation in the first place. Could you, for example, commit to providing a written summary so that the patient trusts that they'll have that key record of the information? How can you address the mistrust if that's what's driving the request or insistence to film? In terms of filming by practitioners of consultations, that will engage the health information privacy rules. And I would encourage, if you are thinking about that, to work through them all very carefully, undertaking a privacy impact assessment before making a decision around when you might be filming or not. I would very much encourage. Why are you filming? Is it necessary? How do you make individuals aware of the fact that they are filming, that you are filming and the purpose for that? Are they able to opt out? Is that going to be a fair collection? For Rule 5, there will be additional security and storage requirements that you would need to work through. And I know that having digital recordings can create a number of headaches for organisations when they're working through their public record requirements, for instance. You must, under that Act, maintain the records in an accessible form so that they can be used for subsequent reference, and do so for the period that those records are under your control until they're disposed of. That does create issues when you've got changes in formatting between the old sort of recording, if you think back, onto VCRs versus DVDs, and now, and they do need to be maintained in a way that complies with the Public Records Act. I also would caution clinicians to think about the fact that it simply won't be possible to review all of the recordings before a clinical consult with the patient. So there will still be the requirement to ensure that the health records are an accurate summary of pertinent information so that they can be quickly accessed and reviewed before providing care. Also, I'd encourage you to look at your own policies. I know that some DHBs, for instance, require written consent before any photograph or recording is made. And there may, of course, be other legislative overlays which you'll need to take into account, particularly in the mental health setting. In terms of CCTV, our office has some guidance around the use of that. People need to be notified of it, how it's going to be used, the purpose for that. It's generally done by signs in public places, for instance. And as I mentioned, there will be additional considerations if you're thinking about using CCTV in mental health facilities, for instance. I'm just going to double check the questions to see if there's anything that's cropped up on that. And I will just, so I'll go back to remote consultations. So I think we're all becoming more familiar with remote consultations. I certainly, it's been a huge upskilling thing for me in terms of Zoom, Teams, not my favourite. And as you'll see, webinars, of which it's still a learning curve. But COVID has affected our lives in a huge number of ways, and the use of technology has been a welcome and useful tool, but has also created a number of complexities. I guess in terms of the use of remote consultations, I would very much stress the importance of ensuring that you understand how the provider you're using, what their security is like. Are they using any personal information or collecting information through the use of that platform? Thinking also about how you can ensure that the the consult and the collection of information is appropriate and fair to the individual? Can you making sure that you're checking, for instance, that they're comfortable, that they're able to share information with you, that there's not, say, their mother, if it's, sitting outside the door, listening in on the conversation? How do you deal with others in the home? That will, of course, have additional complexities if you've got concerns, for example, around family violence, or family members maybe exerting influence over the individual's choices. So these clinical relationship matters that you will be dealing with will continue to be challenges in remote consultations and will be heightened. So privacy is not going to be the only issue that you'll need to consider in terms of the use of remote consultations. There are, of course, and I've got a little picture there of the Medical Council's statement on telehealth, other rules and professional standards that will apply. It's important, for example, to understand the limitations of a remote consultation. There will be times where you will need to do a physical examination, where you'll need to observe or to take measurements, blood pressure, for instance, that you're not able to do over the phone or able to do safely. There are also rules around prescribing when you've only seen someone remotely that you'll need to be cognizant of. I'll just move on to privacy breaches, because I think this is a really important and interesting topic. So a privacy breach is defined in our Act. It's any unauthorised or accidental access to, disclosure, alteration, loss or destruction of personal information, and it includes actions that prevent an agency from accessing the information that they hold on either a temporary or a permanent basis. So if we think about the breach at Waikato DHB, where criminal actors attacked the DHB's IT systems, and it was a denial of service attack, so it meant that the DHB was unable to access the information that they held. So it's a privacy breach on that circumstance. And unfortunately, it became aware that information had also been exfiltrated from the DHB by the criminal actors. So there was an unauthorised disclosure or access to the information. I do want to just note that, of course, the definition of a privacy breach doesn't say anything about the scale or size of it. It can be caused by someone inside or outside the agency. It might be attributable to the actions of the agency or not. It might still be ongoing. It might be large, it might be small, it might involve very personal information, it might not. But it is a very broad definition. A privacy breach will be a notifiable privacy breach when it is that large scale, where it's got where an agency's got a reasonable belief that it will or is likely to cause serious harm to an affected individual. And so where it's a notifiable privacy breach, there is now a mandatory notification obligation. The agency must notify our office as soon as practicable, and they must also notify the affected individuals, again, as soon as practicable, unless an exception applies. And the failure to notify is an offence in respect of non-notification to the commissioner, or may be an interference with privacy in and of itself if it's a failure to notify an affected individual. When assessing whether or not a privacy breach is likely to cause harm, there's a number of factors which the agency must consider. That will include whether or not the personal information is sensitive in nature, the nature of harm that might be caused to affected individuals, who's obtained the information, whether that's known or not, whether the information is protected by a security measure or not, and what actions the agency has or can take to reduce the risk of harm following the breach. One of the questions that was submitted to us in advance was, well, what if we accidentally send the discharge notice to a patient's old general practitioner. So they've come in, they've told us that they've changed their GP, and unfortunately that change hasn't been recorded in the notes, or it hasn't been recorded in a way that has sort of acted to prevent the old GP receiving the discharge notice. Well, it would be a privacy breach. It would be an unauthorised provision of information. It may or may not be a notifiable privacy breach. It will depend. Most likely, probably not. But if the reason why the individual has changed GPs is because there's been a massive breach or just, you know, there's an ongoing complaint to the HDC, there's been a breakdown of the relationship between the patient and the GP. They might be in the context of a complaint to HDC or to the medical council, and say the discharge note is actually around their admission to for assistance for mental distress arising out of that. Much more likely to be a notifiable breach. So context will be really important, as it always is. It's also, I think, really important to recognise that you won't always know exactly what's happened. The Waikato breach, for instance, there wasn't, at the point that they were clear that they'd had a cyber attack, they had their IT systems with a denial of service type scenario, and they've had to close it down. They won't at that stage necessarily know whether information has gone out has been taken by the hackers. And so the Act recognises that there may be the information you can comply with your notification provisions by providing information incrementally. You might not have the full information immediately. It's also not always practicable to notify an affected individual or each member of the group of affected individuals. And in those cases, it might be open to the agency to provide public notice. There's also limited circumstances where notification either to the individuals or public notice, if it's not practicable, isn't going to be required or can be delayed. And importantly, circumstances change. An agency that gives public notice or relies on an exception may at a later date need to notify the individual directly when the circumstances that justify that exception no longer remain. So circumstances will change, and the process that agencies need to follow will need to ensure that there is those feedback loops and review and reconsideration of any exception that's been relied upon. In terms of responding to breaches, the sort of 4 key parts of containment, then assess, notify and prevent will hopefully be familiar to you all. Do plan for privacy breaches. Unfortunately, they do happen, and they can be hugely significant, like the breach at Waikato. Do call us and call us early. The notification obligation is, of course, as soon as practicable. Sometimes you won't necessarily know whether you're dealing with a notifiable one or not, but the earlier that you involved us, the earlier that we might be able to help as well. Containment will take on different things depending on the breach itself. What we have seen recently is that with major breaches or breaches where the media may have information, the use of injunction proceedings to prevent distribution and use of the information can be really important. Learn from all your breaches as well, your serious and not so serious. Take action and put yourself and your patients in the best steps going forward. This reporting of near misses, of adverse events, for example, incident reporting in the DHB should be quite familiar to you. And you will know that actually in those near misses, those lucky escapes, you'll often find out really key things about your system that if you take steps to change your practice now, you will prevent a breach from occurring in the future. I also think there's a lot of lessons that, or resources that you will have internally at DHBs that will put you in a really good position for the notification for individuals as well. You should all be familiar with the open disclosure requirements that apply when there's been an adverse clinical event, and they're very similar in terms of how you will be addressing a notification to affected individuals following a privacy breach, and will have similar needs in terms of how you disclose information and how you take the patient along with you and maintain their trust and confidence in you through the way in which you manage the response to the privacy breach itself. I did ask our data insights person just to pull together a few stats in terms of breaches in the health sector. We do see that the healthcare and social assistance industry is by far the industry that's reporting the most privacy breaches through to our office. So in the year to the 30th of April, you'll see that they're kind of leading the charge really in terms of the reporting of serious breaches. That's not to say that they're necessarily leading the charge in terms of number of breaches. It could possibly be a greater identification and understanding of the obligations to report. But it is something which I think we need to be mindful of. The DHBs are more than half of the agencies reporting in the public, the serious healthcare breaches in the public sector organisations. In terms of types of breaches, you'll see that unauthorised sharing is the largest component of the breaches reported by the healthcare and social assistance industries. There is a little bit of sort of double up, I think, and well, not double up, but oh, I'll move back. Sorry, I'll just move the chair one down. Unauthorised sharing will, of course, I think also include an email error, but there's some types of errors that we're seeing where they're so prevalent that they are useful to show as their own discrete type. If you think unauthorised access will likely also, or use will possibly also encapsulate employee browsing. But we are really wanting agencies to understand and take action where it's an internal access as well. It's not just when information is shared outside of the organisation that you need to be concerned or take action. Also, in the health industry, the most prevalent form of harm that we're seeing is emotional harm. It's the most common type in the sort of breaches as a whole, but you'll see it's almost half of the breaches in the health sector where the core harm that's being caused is emotional harm. And then just in terms of the types of the causes of breaches, absolutely human error is a big factor in terms of the cause of breaches. And you'll see that the distinction between health and other industries in terms of the prevalence of that. Malicious attacks being a higher proportion in other industries than in health. And really reinforce that message that your near misses and your lucky escapes and the privacy breaches where you're able to take action early and to prevent any risk of harm to the individual, those really are opportunities for you to learn and take action and prevent breaches that are more serious and devastating for you and for your patients in the future. Now, if we've got time, we've got 10 minutes, so I have talked a little more than I had hoped, but what I will do is just have a quick look at some of the questions, and if you've got a burning one, please do try and pop something into the Q&A or the chat. Another question from the tertiary institution. If we have a student who has a mental health episode on campus and we have to engage our own health workers or an external agency, any records relating to this will be treated as health information. Is that right? Definitely the records that the health workers and the external agency create and use. I'm not as familiar with the tertiary and how all of that is segmented, but if I was looking at this, say, as a DHB, if you had a staff member that was having a mental health episode and you had to take action as the employer to ensure that they got appropriate support, there would be a separation between the information that as an employer holds relating to the management of that incident. That would be employee information, which would be subject to the Privacy Act, and the information which the hospital would create as a result of providing care to that individual. Again, the separation of those two types of information will be really important internally in terms of how an organisation can use the information. It's not open for your HR department, for instance, to access the clinical notes that you have held by the same organisation, by the DHB, but for a different purpose, for providing care to you. There may be times where HR will have to ask internally for information or through you to get that information, and then that information, to the extent that it's collected and used for your employment purpose, will form part of your HR records, but that they don't meet. So it is really important to be really clear about that separation of different types of information, the purposes for which you've collected and how you can use it, and ensuring that that's managed safely and appropriately when you've got different purposes and different functions within the agency. I'm not sure whether that's totally... the other point I was going to say is that in terms of your holding and use of it, I have made the point, maybe somewhat contradictory, that there's not that much difference between the Privacy Act and the Health Information Privacy Code, but there is, and it's important. Again, it is, and it's important in terms of how it deals with patient authorisation when you're dealing with those exceptions, for instance, which enable you to share information, but you need to first consider or form the belief that it's not necessary or desirable to get their not desirable or practicable to get their consent to the share. But in practice, there are times where the differences are not as important. Oh, yes, thank you, Karen. The voluntary police requests. So one of the exceptions, so when you hold information, you've collected it for a certain purpose, which is to provide healthcare. You can use and disclose it for that purpose. There will be times where the police might ask you for information, and there is an exception in Rule 11 which allows health agencies to share information where it is not desirable or practical to get the individual's authorisation for the share, and where it's considered necessary to avoid prejudice to the maintenance of law, including the detection and prosecution of offences. So when you receive a request from the police, the first thing you really need to be turning your mind to is this a situation where I'm required to provide information? Are they exercising a power that they have to make it a compulsory provision? So if you got a production order, for instance, for the medical records, then you would be required to provide the information that comes within the scope of that order. If it's not that, then you'd need to be tuning your mind to whether or not, in the circumstances, you've got a basis under the Rule 11 that you could share it, and should you be exercising that discretion to share. So as I said, the first thing that you need to turn your mind to is, should I be talking to the patient about this and actually getting the authorisation for that? There will be times where that might, for example, undermine the police investigation. And in that circumstances, you might have grounds for belief, to be reaching that belief that it's not desirable in those circumstances to be getting the patient's authorisation. The patient might be unconscious, for instance, if they're an ED and they've been subject to an assault. So it might not be practical to get their consent. So that's the first question. Do I have a reasonable belief that it's not desirable or practical to get authorisation from the patient? And then secondly, do I believe that it is necessary to share information with the police in order to prevent prejudice to the maintenance of law? And this is where the agency who's sharing the information really needs to be able to justify the fact that that threshold has been reached, and where we sometimes see a bit of a disjunct between what the police are or have provided with an agency. It's not enough just to get a request and for the police to say, well, we need it. You need to be able to reach a reasonable belief that it is necessary. And also thinking about what information is necessary. Do you need to provide the whole clinical file, or is there certain information that you could provide that might be that enough, for instance, for the police to then be able to go away and get a production order if they need to see more? As I also said, the Privacy Act and the Health Information Privacy Code sets out a framework, but it will be how you exercise a discretion will be informed by your professional obligations as well. And there may be circumstances when you're thinking about, should I exercise my discretion, should I share this information with the police, that you'll need to be thinking about the potential harm to the patient in terms of the relationship that they may have with you or to others, concerned that they might not be able to access treatment, that the information will be shared with the police, and it'll be a barrier to accessing treatment. And so there is other sort of professional and ethical considerations that you will need to balance when exercising that discretion. Karen, I hope that helps, but as I said, there is the guidance on sharing information with the police, which we are hoping to update, but it's provided much more in the general sort of setting. And health, as we know, does have those professional ethical overlays, which providers will need to work through to get to balance their duties of confidentiality to the patient and the privacy obligations, and their desire to be a good citizen, and to ensure that there is appropriate information shared with police when necessary. I also think it's really important when you're getting the request from the police to be quite critical. I know that I've previously seen requests where it suggests that there's a requirement to provide that isn't there, or where the production order is much more limited in scope than what the request is that accompanies it. So do be careful and critical, and consider exactly, be very clear, what is the basis on which I've been asked to share? What is the legal basis on which I must share or can share? And is that sharing only the information that is necessary? And when we're looking at a discretionary decision, should I exercise that discretion, having regard to the context as a whole? I think that concludes the questions and our time. So thank you all very much for bearing through this presentation. As I said, I do find the Zoom ones a little bit harder, in part because I can't see your lovely faces and see what you're more interested in or not. I do just, again, say we've got lots of resources on our website, including these wonderful e-learning modules, and we really would like to hear from you as to what you're finding useful, what you'd like to see, how you're using those resources, and we'll send out the survey link. I can include the slides if that's useful, and please do share that survey far and wide within your networks as well, so that we can tailor our learning resources to what is actually of use out there in the sector. So thank you very much for your time.